Again, welcome to our Plan Series webinar. As I'm sure you're all aware, my name is Justin Baumgren, President of Baumgren Retire Plan. I also have with us today our Vice President of Operations, Chris Torres. Today we're going to be talking about beneficiary designations. Feel free to ask some questions using the chat feature within Zoom. We may have some time towards the end of the program to address those. If we're not able to answer those live for you, we can reach out to you personally to get those questions answered for you. But beneficiary designations, why is it important? Well, quite simply, because it can result in your financial assets being distributed to individuals that you didn't want them to. So pretty simple with that. So what are we going to talk about a little bit today? Well, we've divided up some of these financial aspects into retirement, non-retirement, and some other considerations. Well, what does that mean? Well, beneficiary designations is a very specific term when it comes to account titling, who we designate who would inherit this if we were to die. However, it's also sometimes used just kind of more general to talk about distributing assets. And so we've got some other considerations as well that are closely related to really the objective of ensuring continuity in your financial assets. So we broke it up into IRAs, which also includes other retirement accounts, such as 401ks, 403bs, et cetera. Non-IRAs, which were primarily your typical brokerage accounts. And then we'll have some estate planning aspects that we'll talk about in particular. One that Chris will touch upon, a new type of designation, a trusted contact. So we'll talk about those a little bit later. So just to reiterate some common things that we need to know about beneficiaries with IRAs, all qualified accounts need to have beneficiary designations. And really they're broke up into two different types, primary and contingent. Primary beneficiary receives the assets at death. It's the primary, it's first. They must survive you in order for them to receive those. If they do not, if they predecease you, that's where that second comes in, the contingent beneficiary. The contingent beneficiary will inherit your assets only if there are no other surviving primary beneficiaries at the time of death. Now, primary beneficiaries could also have other things like per stirpes and so on and so forth. We'll talk about that in a moment. But generally, when it comes to IRAs, who can be beneficiaries? Well, for all intents and purposes, to transfer an IRA, an account owner of an IRA or a qualified plan, one needs to be a natural-born individual having a social security number, meaning for the most part, charities and trusts cannot own IRAs. They can receive IRAs. So in many cases, the beneficiaries of an IRA, if charities, trusts, and so on and so forth, will not be able to take advantage of some of the advantages that natural citizens have inheriting IRA qualified plans. So what is going back as we've designated and determined who is our primary, who's our contingent? Oftentimes maybe spouses would be our primary, children, and so on and so forth. Contingent would be those what-if scenarios. But another way to ensure that the primary contingents are categorized properly, per stirpes is one. Now there's a couple different there that you can elect by default. Is per capita. So if you don't click that box that you see there on the screen, it's default per capita, which is some lawyer lingo, Latin there, meaning that the per capita, the share of any beneficiary that predeceases you in death will share equally among the remaining beneficiaries. So for example, if you had 3 beneficiaries, if one predeceased you, The remaining two would get 50%. Per capita, that's the default per stirpes. Then it would go down to the root. Per stirpes passed to the living descendants instead of being reallocated amongst those living beneficiaries. So that 33% would go, in that case, to any living relatives of that predeceased primary beneficiary. So those are important to know. The default is per capita. The remaining primary beneficiaries get that equal share if they predecease you. Per stirpes keeps it going down the channel. Sometimes that's important when it comes to, especially with children, with making children as a primary beneficiary. You want to understand the per stirpes per capita rules when making those designations. Now, wanted to take a little sidebar and talk about, well, what happens after individuals inherit. So we broke it up into two different areas. When a spouse inherits a qualified plan, retirement plan, or an IRA, and when a non-spouse inherits. Now, generally, the spouse has the most advantageous benefits when it comes to inheriting an IRA. So they got three options. So they can either roll it over into their own, they can treat it like it's their own, or just remain the beneficiary. So oftentimes a spousal beneficiary will just treat it as their own. They'll take it over. Beginning in 2024, the recent Secure 2.0 Act allows surviving spouses to be elected to be treated like the deceased spouse. Now, this would come into play if the deceased spouse was much younger. That means you could delay RMDs until the deceased spouse would have reached RMD age. So, for example, if your deceased spouse was 10 years younger than yourself, and you took that IRA over as your own, now you'd be next in line with those RMDs. So whenever that would happen, but now a new rule with the Secure Act is you could treat it like it's their age, so thus delaying RMDs based on what their age would be. So that would really, in the use case scenario, be when the deceased spouse would happen to be significantly younger. But for the most part, what happens the most is the spouse just takes it over as their own IRA. So obviously the most advantageous. Those types of benefits are not available to non-spouses. If the deceased had reached retirement RMD age, which is now 73, there's a life expectancy rules for that deceased person. Otherwise, if they have not reached that, you've got that 10 years. You've got 10 years to distribute those assets out of the qualified plan. Now, of course, a non-spouse would also be, for example, a trust. So the recent Secure Act allowed for trusts to be able to, in certain instances, be able to then inherit an IRA if all the beneficiaries are also people. So they can't be companies or other trusts. So options that if you designate perhaps your trust as a beneficiary, if it doesn't meet those certain conditions, all of the assets would need to come out of the IRA minus taxes and then land into the trust. If certain conditions apply, like for example, if the trust turns into an irrevocable trust at death, then they can stretch that over 5 years. So that's a new feature. So non-spousal beneficiaries, just to reiterate, oftentimes the 10-year rule will apply. It'll stretch over 10 years to distribute that. If it's a trust, certain conditions, you can have it stretched over 5 years. But oftentimes trusts may not meet those types of qualifications, more even need to. Sometimes trusts are marital trusts shared with husband and wife. And again, the spouse has the most advantages when it comes to inheriting it as well. So that wouldn't be really an issue. So getting back onto track to beneficiary designations, Getting into now the next section, non-IRAs, non-qualified plans. So on your typical account application, there's really no section for beneficiary designations. You achieve the same type of continuity through titling. So joint accounts, different joint with rights of survivorship, community property, etc. Those are some ways that we can provide continuity of the assets in the case of death. But there are ways as well to provide designation. So that would be, for example, in banking type of account CDs, you might be familiar with the terminology POD, payable upon death. Similarly, with investment accounts, brokerage accounts, one can designate a TOD, transfer on death. Similar to a beneficiary form, the individual is assigned then to receive the assets upon death. So very similar to a beneficiary designation, though not technically called a beneficiary designation. This too ensures that continuity of those accounts. Beneficiaries, in this case, they're not as restrictive as IRAs because of the IRAs having such nice tax advantages. TOD is not in that case. Beneficiaries can be individuals, trusts, charities, so on and so forth, without having to liquidate any of the assets. And oftentimes with individuals, you get a step up in cost basis. So if you've had assets that you've held for a long period of time and afraid to sell because of the tax consequences at death, you get a step up. So that's an advantage. So now I talked about in the beginning that there are some other considerations. Beneficiaries sometimes just used generally to describe that process of making sure continuity. So we wanted to wrap in together as well some other things that often fit into that world of providing continuity, such as wills, trusts, as well as trusted contacts, which is really a new form created a few years ago out of some legislation to ensure against for a few things, things like elder abuse, fraud, and so on and so forth. And it's kind of evolved into something that is just kind of wise today that we should think about. But first off, what are wills? Well, a will can be used for smaller, straightforward estates where it designates who's going to receive physical assets, etc. It does not override beneficiary designations. Nearly all should have a will, but to note, a will does not trump beneficiary designations or other things like TODs. So a will, it does not trump those. So it's really designed to be used for all these other things that you might have, your wine collection, art collection, perhaps other accounts as well. And what's its purpose? Well, the purpose is to smooth the probate process. A will does not circumvent it. It just helps to facilitate and smooth that out. Probate is a court proceeding that is used to distribute assets, so a will is helpful and can keep costs down because probate without can be more expensive. So it's a process to help then facilitate that. And again, what is our goal? To make sure that our financial affairs, our financial assets go to the person that we want them to go to. So again, this fills that need. Now, trust as well for maybe more complicated designations. For example, you would like your spouse to live in the house while they're living. However, at their death, it goes to maybe children from your first marriage, etc. That cannot be done through any sort of beneficiary form. So those types of sophisticated planning needs to be done through trusts. A trust can avoid the probate process. However, the revocable trusts there, you can retrieve those assets back during the lifetime. So revocable versus irrevocable. So again, trusts, they're legal entities which are designed really to help avoid some of that probate process. Again, when it comes to trusts, revocable versus irrevocable, that gets us into a whole nother world of estate planning with inheritance taxes, but we don't want to get into that right now. We just want to focus on the distribution of assets. So another common way that we achieve the distribution of assets is through trusts. But lastly, what we wanted to talk about that really affects all who have brokerage accounts is trusted contacts, as we mentioned before. Now, trusted contact is not specifically a beneficiary form, but this can be a well-used asset for continuity of your assets. So at this time, we're going to give our attention to Chris, and he's going to take us through what the trusted contact form is, its purpose, and how to find it.
Hello, everyone. Before we go into the details of the trusted contact, what they are, I want you to think for a moment about a moment specifically where you had a very important phone call to make, and you look at your cell phone, but you notice that you have no bars. You have no cell phone signal. Maybe you're stuck in traffic, stuck in a tunnel. Maybe you were traveling abroad. How do you feel in that moment? Well, it's very likely that all of us have experienced this, or at least something like this, right? Which reminds us as your advisors that we want to be prepared. So we're going to talk a little about the trusted contact. First of all, let's define what a trusted contact person is. And the SEC defines a trusted contact person as a person that you authorize your financial firm, it could be your broker-dealer or us, to contact in what we call limited circumstances. And specifically, this limited circumstances are moments in which we can't communicate with you through the normal channels. It may be that we have trouble reaching you physically. It could be that we have trouble contacting you through the phone. For example, the example I mentioned earlier, no signal, no battery. Maybe you're traveling abroad, or maybe even traveling stateside, or maybe you've even suffered a medical emergency. Another example of what we call limited circumstances here would be a moment in which we have a reasonable belief that your account may be exposed to possible financial exploitation. For example, we might receive an email from a person claiming to be you, but it looks a little suspicious. And while we're defining what a trusted contact person is, we should mention that it must be an adult, 18 years or older. And another very important reminder is these words here in bold. It's also mentioned by the SEC that naming someone as a trusted contact person does not give that person any authority to act on your behalf, execute transactions, or engage in activity in your account. So this person does not have power of attorney. And hopefully, now that we have a better idea of what exactly a trusted contact person is, we talked about when we might reach out to this person, but we might ask ourselves, when would we reach out to this person? And our next slide here gives us a couple of reasons. And the primary reason why we would reach out to a trusted contact person is when we need to verify. For example, a trusted contact person allows us to verify a couple of things, specific details, information. For example, if we cannot reach you, a trusted contact person may help us ensure that your current address and your contact information are correct. Maybe you moved and you forgot to tell us, or your broker-dealer. Also, if we suspect that you're experiencing a health issue, it may help us confirm your current health status. And the truth is, when we're having a medical emergency, our first thought isn't, I should really tell Justin and Chris. I should really tell my financial advisor, right? And we understand this. But having a person designated as a trusted contact can help us verify this information. It might also help us verify the identity of any person that you have designated as a legal guardian, an executor, a trustee, or any holder of a power of attorney on your account in the case that you're not able to make decisions. Which also reminds us that a trusted contact person also adds an extra level of protection. And I mentioned another example a little earlier today. Perhaps we received an email or a phone call from a person claiming to be you, but it seems off character, seems suspicious. Again, verifying your information with your trusted contact person will help us respond to any financial exploitation, any fraud that your account might have. And of course, in the end, it will help us protect your assets above all things. And after considering all these things, we might be even feeling a little eager to add someone as your trusted contact. We might even have someone very specific in mind. So our next slide, how do we add someone as a trusted contact? Well, on our website, baumgartenretireplan.com, we navigate towards the Plan App section. And if we look at our next slide, this is a new feature that we've added to our website, the Plan Apps. They're highlighted in red. And if we click there, it takes us to the next slide to choose your navigation. And we will select this box here, Customer Service Selection. And that takes us to our next page, which is the quick references, also our most common forms that we use. And under the common forms there in the bottom, you will see the Trusted Contact Form Request. And if you click that, it'll take us to this very simple form. We call it the Request for Trusted Contact Authorization. It's a very simple form. You fill it out with your personal information. We're not going to go super into the details, but it'll ask you a couple of the details, a couple of the facts about your trusted contact person. And after you're done, you click Submit. We verify this information. We make sure that we verify your identity. We make sure that it was you who actually sent it. And then we will input that into our legal document, which we will send through DocuSign. And for those of you who haven't used DocuSign yet, I can say that DocuSign is a very wonderful tool that we use for signing documents. It's very secure and it's very, very simple to use. And it allows us to be very consistent in our documents and safekeeping. So if you have not done so yet, and you have any questions or you need us to walk you through it step by step, Justin and I, of course, will be very, very happy to help. We sincerely mean this. So please feel free to reach out. Any help that you need, we will be able to help you walk through step by step. Now let's give our attention back to Justin.
Okay, thanks, Chris. Appreciate that. May have not heard of a trusted contact. Many firms have trusted contacts for those same reasons. So we encourage you to consider that as well. So we hope that you found this webinar beneficial. Just wanted to reiterate, it's always good to routinely check to make sure that our beneficiaries are in line with our wishes. And it's good as well to vet these through a financial advisor to make sure, because of the legalese and other matters, that they are in fact going in the way that you recommend. And lastly, other considerations when it comes to wills, trusts, and trusted contacts as well can just add some icing to the entire estate distribution plan. So we thank you all for your attention today, and that's all of our time. I don't see any questions in our chat, but feel free to reach out to us personally if you have any questions. Again, thank you all for your time and look forward to seeing you next time.